Oh, hey, what up? It's me, your boy. Oh, my thing's all tilted. Oh, there we go. I was told stream was upset that I wasn't eating in front of stream, so I brought a potato. Crinkle, 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 crinkle. It's actually just a potato. Also, Puck is here. Alright, sorry, I couldn't help it. There's nothing even on it, it's just a potato. Okay. So, this could be a little bit... What has happened here? Whoop, there we go. Alright. Let's, am I bumping into the mic? I don't know, I might be. Okay. That potato needs some cheese and sour cream, maybe? That'd be so good. Well, good afternoon, everybody. Or morning. Or night. Depending on where you live. Last time on Dragon Ball Z, we were laughing our asses off at some people claiming they were going to be streaming to the Non Sequitur Show channel of like April of last year. Bless their little hearts. So at this point, we had went through, it was decided to go to business court, it went to business court, Kyle didn't respond, a partial judgment went through, for Steve to win and own everything, Kyle being guilty of what he was accused of, and that Kyle was to turn over the books so that way they could finish the judgment with the amount of money that was due. Kyle then responded saying that he was complying by not complying, and then 2 days later decided that he wanted to say that, no, well, actually, I didn't even get the summons in the first place. So, we went through Kyle's letter and his orders. Then Steve's lawyer had responded. We went through that, and it was essentially saying, yeah, he did receive service. Here's all the evidence that he did receive service, and now it's on him to show that he did not, and how, in fact, he did not, as well as a order to show cause for why is Kyle not in contempt. Alright. Sorry, Dapper is correct. Not guilty, but he's liable of those things. Since this is not a criminal case yet. Yet. So, we made it all the way through, reading all of what Steve's lawyer had to say. Now we are at what the court has to say. So let's take a look-see. This is State of North Carolina, Guilford County, Steve McRae, plaintiff versus Kyle Russell Curtis, defendant in the General Order of Justice, Superior Court Division 19 CVS 8163, order on motion for order to show cause and motion to set aside. Now pending before the court are Plaintiff Stephen McRae's, Mr. McRae, motion for order to show cause, motion to show cause, ECF number 23, and Kyle Russell Curtis, Mr. Curtis, revised motion to set aside default judgment, motion to set aside, ECF number 20. A hearing on each of these motions would be appropriate prior to ruling. However, absent mutual consent, no hearing can be held until or after June 1st, 2020, pursuant to the orders of the Chief Justice of North Carolina Supreme Court. Covfefe was happening. The court further finds that it should not issue further ex parte relief beyond the partial judgment by default. So that is saying that the partial judgment stands, but not going to issue anything further, like, beyond that. It entered in this action on January 23rd, 2020, ECF number 17. The court further acknowledges Mr. McRae's report that Mr. Curtis has failed to comply with that judgment and has therefore requested that an order be issued to compel Mr. Curtis to appear and show cause why he should not be held in civil contempt pursuant of Section 5A-21A of North Carolina General Statutes. Mr. McRae supplemented his request by a supplemental affidavit, ECF number 25, filed on March 27, 2020, asserting that Mr. Curtis had failed to abide by the court's instruction in the judgment, including not turning over the Non Sequitur Show Twitter account, but instead deleting it. 02-12-20, McRae Affidavit, Paragraph 13, Compliance Order 7, ECF number 18. Not turning over access to the Non Sequitur Show Discord server, which Mr. Curtis contends he does not administer, a contention with Mr. McRae challenges in his affidavit 02-12-20, McRae Affidavit Paragraph 14, Compliance Order Number 7, not turning over ownership of the YouTube channel, but instead stating that he intends to retain 50-50 ownership of the channel. 02-12-20, McRae Affidavit Paragraph 13, Compliance Order 7, providing a list of inaccurate usernames and passwords for accounts associated with Non Sequitur, 02-12-20, McRae Affidavit Paragraph 12, and failing to provide any financial documents, 02-12-20, Paragraph Affidavit Paragraph 1. Mr. McRae Affidavit Paragraph 1. The purpose of civil contempt is to preserve the rights of private parties and compel obedience to orders and decrees made for the benefit of such parties. Till v. Berry, 234, North Carolina, App 96, 102, 758, SE 2D, 411, 415, 2014, citation omitted. The court may initiate civil contempt proceedings upon a finding of probable cause. CGS paragraph 5A-23A. See also Palsman v. Decca Furniture, USA, Inc., 2016 NCBC Lexus 20 at pound 6. Asterisks. Oh, is it pound the number sign? Whatever. Asterisk. NC Superior Court, February 26, 2016. Quote, probable cause refers to those facts and circumstances within the judicial's official knowledge and of which he has reasonably trustworthy information which are sufficient to warrant a prudent man in believing that the alleged contender is in civil contempt. Young versus Mastrom Inc. 149 NC App 483-484 to 85 560 SED 2D 596 597 2002. Quote State versus Williams 114 NC 337-343-333 SE 2D 708 713 in 1985. Bruh. Proceedings for civil contempt may be commenced, quote, by the order of a judicial official directing the alleged contender to appear at a specific reasonable time and show cause why he should be held in civil contempt. Why he should not be held in civil contempt. NCGS paragraph 5A-23A. Such an order may be issued on the affidavit of one with an interest in enforcing the order and a finding by the presiding judicial office that there is probable cause to believe the alleged contender should be held in contempt. ID, see also Shoemaker versus Shoemaker 137 NC App 7276 527 SE 2D 5557 2000. Once it is determined that probable cause exists, the burden shifts to the alleged contender to show that he should not be held in contempt, that he lacks the means to comply, or that his noncompliance was not willful. Shoemaker 137 NC App at 76 527 SE 2D at 57. Quote, A court's only means of compelling compliance for a person found in civil contempt is imprisonment, as long as the civil contempt continues. Subject to certain time limitations. See NCGS paragraph 5A 21B. An order holding a party in civil contempt must specify how the party may purge himself or herself of the contempt. NCGS paragraph 523E. And imprisonment, oh my goodness, must end once the person has purged himself or herself of contempt. SCGS paragraph 5A 22A, because civil contempt seeks to coerce compliance rather than punish. The purge provision is essential to a civil contempt order. Dapper plot twist. Kyle's been in a coma the whole time. Ah, check out season 7. God. Red Valve Inc. versus Titan Value Inc. 2019. NCBC Lexus 57 asterisk 79 to 80. NC Superior Court September 3rd, 2019. Quoting Ray Lackey Enters Inc. versus Ville in Lakeside Inc. 2016. NCBC Lexus 9 at asterisk 23. North Carolina Superior Court January 29th, 2016. Materials of record and rebutted affidavit testimony filed to date support a finding that there is probable cause that Mr. Curtis willfully violated the court's January 23, 2020 judgment, and specifically that he has failed to provide Mr. McRae with the accounts associated with the Non Sequitur show, has failed to relinquish control of the associated YouTube channel, and has not timely produced the requested financial documents. 02/12/2020 McRae affidavit paragraph 12 to 13, 16. Mr. Curtis has not responded to Mr. McRae's latest filing, and he is not required to under the orders of the Chief Justice. But for those orders, the court would issue Mr. McRae's request order that Mr. Curtis appear and show cause why he should not be held in civil contempt until he has fully complied with the court's judgment or demonstrated adequate grounds that such judgment must be set aside. In light of the court's inability to proceed in that matter, Covfefe was happening, is still happening. But the court advises Mr. Curtis that the court's judgment remains in full force and effect, and that while the court makes no final findings or facts or conclusions of law prior to a hearing to be scheduled, if Mr. Curtis in fact has willfully violated and continues to violate the court's judgment during the period in which the court is unable to hold the required hearing before finding him in civil contempt, the court will give appropriate consideration to imposing all permissible sanctions, and if necessary, requiring Mr. Curtis to be imprisoned until he fully complies with the court's orders. Mr. McRae, in turn, is advised that the court will respond appropriately if his assertions prove to be without basis. The parties should govern themselves accordingly. This, the 13th of April, 2020. That was the court. That's what the court was saying. Bruh. Bruh. God, that was 26. So 27. We've jumped from 04/13/2020. We are now jumping to 06/15/2020. So this is an affidavit. This has been a second supplemental affidavit of Stephen McRae. This is filed by Steve's lawyer. North Carolina, Guilford County, Stephen McRae, plaintiff versus Kyle Russell Curtis, defendant in the General Court of Justice, Superior Court Division 19, CVS 8163, court, second supplemental of affidavit of Stephen McRae. Hold on one second, I need a bite of this potato. I am a potato. Sorry. I know some people hate that, and I can't help it. I like to be an annoying little shit sometimes. And in Treeland makes a good point. Yes, that was a 2-month gap. And of course, the court's order was until June, and now this is past that June date that this is getting submitted. So here, let me just open this again real quick. This order said that the hearing could not be held via the Supreme Court saying you're not allowed. Here we go. A hearing on these motions would be appropriate prior to ruling. However, absent mutual consent, no hearing can be held until on or after June 1st, 2020. So they weren't allowed to hold anything until June 1st. Steve's lawyer filed this on June 15th. So they waited a bit and then filed this. So that's one of the reasons why there's such a big gap, but the court didn't say anything, so it looks like the court hadn't scheduled anything before this affidavit is. That's what I'm trying to say. There we go. Words and shit. Yeah, let's take a look at this affidavit. I, Stephen McCrae, being duly sworn, states as follows. I am over the age of 18 and incompetent to make this affidavit. I previously submitted an affidavit in support of my opposition to defendant's motion to set aside default judgment and in support of my motion for order to show cause, ECF number 22, and a supplemental affidavit, ECF number 25. This affidavit supplements those prior affidavits. Mr. Curtis is still the only one with access to the channel, and despite the court's admonition that the judgment remains in full force and effect, ECF number 26, paragraph 10, Mr. Curtis has continued to defy the judgment by refusing to turn over ownership to the channel, the Twitter account, financial records, or any of the other related items he has been ordered to turn over. So at the end of the order, they were like, listen, the judgment is still in full force, follow the judgment or else. And now Steve is here 2 months later saying he still hasn't turned anything over. And it is now 2021, and, we're still here. Say no! Spoilers in the chat, guys. Come on. In late May, Mr. Curtis used control over the Non Sequitur show and associated accounts to falsely accuse me of copyright infringement. That's right. I keep forgetting about this one. So, Steve was given the channel by law. Kyle refused to give it to him and then used that channel that Steve owned to false DMCA strike Steve's regular channel 4 times. And for anybody who knows anything about YouTube and DMCA strikes, you have to sign on penalty of perjury. Just pointing that out there. In late May, Mr. Curtis used his control over the Non Sequitur show and associated accounts to falsely accuse me of copyright infringement. False representations that specify material or activity infringes the copyright is forbidden under the Digital Millennium Copyright Act and can be subject to the person making the reports to damages, including costs of attorney fees. 17 U.S.C. paragraph 512F. I have a second YouTube channel simply called Steve McCrae. On May 29th, 2020, I received a notification from YouTube that someone purportedly on behalf of the Non Sequitur show had issued a copyright infringement notification concerning a video I posted on my channel. I immediately responded, disputing the notification. A copy of the notice and dispute is attached as Exhibit A. On June 8th and 9th, I received 2 more notifications from YouTube that the Non Sequitur show had issued copyright infringement notifications concerning 2 other videos posted on my channel. I responded disputing those notifications. Copies of these notifications and disputes are attached as Exhibit B and C. On June 10th, I received a 4th notification from YouTube that a copyright infringement notification had been issued about another video on my channel. This time, the party presenting the complaint was identified as Kyle Curtis. I responded disputing the notification. A copy of this notice and dispute is attached as Exhibit D. Because my YouTube channel has received multiple copyright infringement strikes to date, YouTube is threatening to disable my channel, see Exhibit C. Moreover, I am unable to stream on my channel for the month of June, which directly affects my ability to earn income from my channel. Each of these 4 copyright infringements notifications are false, and Mr. Curtis knows they are false. The videos were created by me. The overlays used with the video were created for the Non Sequitur Show and are the property of the Non Sequitur Show. Items created by the Non Sequitur Show belong to the show. I am supposed to be the primary owner of the Non Sequitur Show pursuant of the judgment. Mr. Curtis has no ownership or rights in any of these videos. In order to submit a copyright takedown notice to YouTube, the submitting party must assert under penalty of perjury that the complaint is accurate. A copy of YouTube's copyright infringement notice requirement is attached as Exhibit E. As discussed above, Mr. Curtis would be liable for my damages pursuant of paragraph 512F of the Digital Millennium Copyright Act. I am currently examining my legal options with YouTube and other forms to vindicate my rights. Mr. Curtis continues to willfully violate the court's judgment during this time when the court has been unable to hold hearings because of Covfefe virus. Rather than comply with the judgment, Mr. Curtis has increased his efforts to intentionally harm Mr. McCrae. Further, the affidavit saith not. Blah, blah, blah. 15th day of June, 2020. Notary. Not notary. Certificate of service. The undersigned hereby certifies that a copy of the foregoing was served via email and United States mail, first class postage, prepaid, on defendant address as follows: Kyle Russell Curtis, 1532 Providence Church Road, Pleasant Garden, North Carolina 27313, and 2435 Anna Garrison Road, Charlotte, North Carolina 28263. And then emails on the 15th day of June 2020. I wonder how Ben must have been like, what is all this? What and why am I getting all this mail? What the fuck? Alright, let's take a look at the exhibits, shall we? Exhibit A. YouTube. No reply. Copyright takedown notice. Your YouTube video has been taken down. Aaron Raw versus Aaron Raw and Kent Hovind discussion between doubt and devout. Trailer 2. To McCrae. Hi, Steve McCrae. Due to copyright takedown notice that we received, we had to take down your video from YouTube. Video titled, video URL, takedown issued by the Non Sequitur Show. That means that your video can no longer be played on YouTube. You received 1 copyright strike. You now have 1 copyright strike. If you get multiple strikes, we'll have to disable your account. To prevent that from happening, please don't upload videos containing copyrighted content that you aren't allowed to use. Thanks, YouTube. Exhibit B. YouTube. A copyright notice takedown. DEFCON 1 Science, episode number 4. Before the Big Bang, question mark. An epic space stream. Takedown issued by the Non Sequitur Show. You now have 2 copyright strikes. Exhibit C. Hi, Steve McCrae. Due to a copyright takedown notice, we had to take down your video from DEFCON 1 Science, episode 2. Some of the hottest things on Earth: how nuclear weapons work. Takedown issued by the Non Sequitur Show. This means you're no longer going to have 3 copyright strikes. As a result, your account is scheduled to be disabled in 7 days. Man, YouTube is so ominous about this, especially when you receive all these strikes like on the same day. Womp womp. Exhibit D. Hi, due to a copyright notice we received, we had to take down your video. DEFCON 1 Science, episode 3. Polonium Halos Explained. Takedown issued by Kyle Curtis. You received a copyright strike. You now have 4 copyright strikes. As a result, your account is scheduled to be disabled in 7 days. Your channel will remain live for the next 7 days to allow you to seek resolution and keep your channel up. If you believe that you are not at fault, blah, 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 blah. Thanks, YouTube. Copyright infringement notification requirements. The easiest way to file a complaint is to use our copyright removal web form. Copyright takedown notifications must include the following elements. Without this information, we won't be able to take action on your request. Your contact information, a description of your work that you believe is being infringed, each allegedly infringing video's specific URL. So I'm pretty sure you can do more than one at a time, but so you can like issue 1 copyright takedown, but it takes down more than 1 video. I think. I'm not 100% sure because it also may have changed. See, it says exact videos, but Kyle specifically did it separately so that way Steve wouldn't be able to stream, because if you do it that way, it lets you spread out spread it out in a way that stops Steve. Like, it was purposefully done that way, essentially, is what I'm saying, to try and cause that as much harm as possible. You must agree and include the following statement. I have a good faith belief that the use of the material in the manner complained is not authorized by copyright owner, its agent, or the law. And the following statement. The information in this notification is accurate, and under penalty of perjury, I am the owner or an agent authorized to act on behalf of the owner of the exclusive rights that is allegedly infringed. Your signature. Copyright takedown notice, blah, 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 blah. Do not make false claims. Misuse of this process may result in the suspension of your account or other legal consequences. And then there's the fair use stuff. I'll leave this on a screen for a second so people can pause if they want to, because I'm not going to read this. Who cares? Everybody knows this stuff. So let's take a look here. Number 28, notice of appearance. Hey, check it out. Kyle got a lawyer. So all throughout this time, all before this, everything before 28, the entire time Kyle was claiming he had representation. He was claiming that he had a lawyer or some kind of legal representation. This is the first time, 07/09/2020. So this went through. A month nearly went by. This is July 9th now. All right? So everybody understands the timeline here. State of North Carolina, Guilford County, Steve McRae, plaintiff versus Kyle Russell Curtis, defendant. Oh, and by the way, you'll notice that Kyle didn't actually respond to this until here, which is just an amended motion to set aside. So the amended motion to set aside for entry of default and partial default is just... Oh, wait, that's not even him. Kyle's amendment. Yeah, so they started off here and didn't actually respond to this or the stuff we covered yesterday. So, let's take a look-see. Kyle got a lawyer. State of North Carolina, Guilford County, Stephen McRae, plaintiff versus Kyle Russell Curtis, defendant in the General Court of Justice, Superior Court Division 19, CVS 8163. Notice of appearance. Scotty Forbes Lee of Ellis and Winters LLP hereby gives notice of her appearance as counsel for defendant Kyle Russell Curtis. Ms. Lee respectfully requests that copies of all notices, motions, and all other pleadings in this case be served upon her address below. This is the 9th day, and then the address, and then certificate of service. Yeah, thanks, cool. I don't see the electronic filing. And then there's their address, whatever. So, keep in mind, so one of the things that we found out during this case is Scotty Lee Forbes here used to work with / for the judge that was presiding over this case, which is kind of hilarious. So, in response to that, we've got... Steve's lawyer popping on in here. North Carolina, Guilford County, Steve McRae, plaintiff versus Kyle Russell Curtis, defendant in the General Court of Justice, Superior Court Division 19, CVS 8163, supplemental affidavit in opposition to motion to set aside. I really hope that now that Kyle has a lawyer, his stuff that he submits is a lot easier to read through. So this is a supplemental affidavit in opposition to the motion to set aside. I see Scott Myers being duly sworn to state as follows. I am over the age of 18 and I am competent to make this affidavit. I have been the attorney of record for plaintiff Stephen McRae in this case since the case was filed. The purpose of this affidavit is to show new facts concerning the address of defendant that have come to light since defendant's motion to set aside was filed. From commencement of this case, I have caused staff in my law firm to send various pleadings and correspondence to the defendant. Initially, we believed that defendant's physical address was 1532 Providence Church Road, Pleasant Garden, North Carolina 27313, the Pleasant Garden address. Excuse me. This was based on the information obtained from plaintiff C. McRae, affidavit ECF number 22, paragraph 3 to 6. The summons and complaint were served by certified mail to the Pleasant Garden address, and the return receipt was received, signed. We filed the affidavit of service in process of ECF number 7. Since the service of the summons and complaint, we have filed several additional pleadings. All pleadings were served to the Pleasant Garden address. At no time has any of the mail we sent to Pleasant Garden been returned for any reason. On February 6, 2020, after his default had already been entered and partial judgment by default had been granted, defendant filed his motion to set aside based apparently on the allegation that the Pleasant Garden address was incorrect, ECF number 19. Defendant alleged that he had moved to 2435 Anna Garrison Road in Charlotte, the Charlotte address. From that time forward, all pleadings mailed to the defendant were mailed to both the Pleasant Garden address and the Charlotte address. On June 15th, 2020, my office filed the second supplemental affidavit of Mr. Stephen McCray, ECF number 27. As shown by the certificate of service, the second supplemental affidavit was served on both the Pleasant Garden address and the Charlotte address. The envelope addressed to the Charlotte address was not delivered. Instead, it was returned by the post office marked "Return to sender vacant, unable to forward." That's such a big oof. That's like, listen guys, I'm not living here, I'm living over here. Okay, well, we'll send it to both. Sent it to this guy. Sent it to this guy. This one came back. This one never did. Weird. Funny that. A copy of the envelope showing the mark from the post office is attached as Exhibit 1. In addition, defendant started a GoFundMe campaign to help him raise money for his legal fees. A screen print of that GoFundMe campaign is attached as Exhibit 2. As shown on page 3 of Exhibit 2, Mr. McCray's location is given as Pleasant Garden, North Carolina. Further, the affidavit saith not. 13th day of July. Certificate of service to, this is now going to Kyle's lawyer, that's why this address is changed. Exhibit 1. Okay, this is the attorney, right? Hey, rotate. Hey, there we go. Kyle Curtis, 2435 Anna Garrison Road, Charlotte, North Carolina, 28263. Return to sender, vacant, unable to forward. Exhibit 2. Oh, I gotta put it back. There we go. Legal retainer to fight Steve McCray's lawsuit. Raised $5,080, $5,000 goal, 99 donors, 12 shares, 99 followers, share, donate, anonymous 10, time to take out the trash 5, anonymous 5. Kyle Curtis, organizer of this fundraiser, created June 16th, 2020. I'm Kyle from North Carolina. Hi, Kyle. This is a campaign to help raise funds to assist me in paying for a legal retainer in the case of McCray versus Curtis over the Non Sequitur show. A default judgment was entered in the case after McCray inappropriately served me, and I am now fighting to get the motion set aside. Want to talk about, hey, does anybody want to talk about fraudulent fundraisers? Since that line right there makes that completely fraud, because he knows that that's a fucking lie. Well, I can cover a large portion of what retaining my attorney is going to cost because he lied about having an attorney. I am unable to afford the entire amount, so I am asking for assistance. I'd like to thank everyone for... It stops. Today, by Kyle... retainer... 6... Oh, that's just a printing. Updates for today by Kyle Curtis. Hello all. I'd like to say again how much I appreciate you all for all you have done for me. Won't forget it. Each of you, heart. June 23rd, Kyle Curtis, organizer. Good afternoon, everyone. I just wanted to thank you for helping me achieve the goal of this fundraiser. I'm incredibly humbled and grateful for this outpouring of support from the community. June 19th, 2020. By Kyle Curtis. Hi everyone, the comments you've been leaving are so funny. I have decided to read some of them tonight at 9 p.m. Eastern on Unirock stream. Thanks again for all your support and tune in tonight. Organizer, contact, Pleasant Garden, North Carolina. I can cover, Ash Scott says, I can cover a large portion of $5,000. Kyle never spent the money and can pay Steve. Smitty, I love each of you, said the two-faced backstabber who robbed his entire fan base and partner. Oh, fucking Jesus. The savagery, the absolute savagery of this. Kyle Curtis, organizer, Pleasant Garden, North Carolina. Hey guys, listen guys, I was improperly served to the wrong address, said Kyle from Pleasant Garden, North Carolina. Listen, I've been hearing lots of things about different fraudulent fundraisers going on and people who may or may not support said fundraisers. I don't know how much more fraudulent you can get than that. Listen, my name is Kyle, I'm from North Carolina, and this guy served me in Pleasant Garden on purpose so I wouldn't file. I'm currently in Pleasant Garden, North Carolina. I forgot how funny a lot of this is. When they learn false strike campaigns never work, go get 'em, Kyle. What? Oh, hey, Dana McWhite. When we fall, we get back up, stay driven, and give 'em hell, Kyle. It's going well. Dear Steve McCrae with 2 M's. The English language donated. Spelled it with 2. Proofreaders is an extremely useful tool. Just say... Zeshi for 56 says maybe it's a different Pleasant Garden address. Maybe, but he said he was in he said he was in where did he say he was? Not Pleasant Garden and Charlotte. He said he was in Charlotte, which is still in North Carolina. It's just in a different section of North Carolina. So if he was gonna argue it was a different Pleasant Garden address, he shouldn't have said he was in Charlotte. Oh, everything. I need to boop Puck. Where's Puck? Puck, you need boops. Puck, come here. Oh, good boy. Boop. Oh, you're such a good boy. This is too funny. Mwah. Kiss you on the nose. He gets extra love, because I can't with this. This is too... Karen Boomer McCrae donated 5. Steve is a petty little penis. You're donating $5 to a fraud campaign, calling yourself Karen Boomer and McCrae, and you're saying Steve is petty. I can't. The irony has left the building. The self-awareness. Just everything about this makes me so happy. Question, is this the bigger oof than the other stream? Oh, good. I don't know. I'm gonna need you guys to vote. You tell me. You guys tell me which is the bigger oof. That or the one from last week. They're all the oofs. Everything about this is oofs. So let's... Oh, how long we at here? How long we been live? I don't even know. I don't know what year it is. What's going on? Oh, it's only been a half an hour. Okay, so I'm gonna do these. I'm gonna go to 30, and then I'll switch out from there. So this is 29. North Carolina. I can't. Hold on. I'm gonna take a bite of potato. This is what the potato brains. Those comments were so big potato brained that I needed to start consuming a potato. Ugh. North Carolina, Guilford County, Steve McCrae, plaintiff versus Kyle Russell Curtis, defendant, in the General Court of Justice, Superior Court Division, 19 CVS 8163, supplemental affidavit in opposition to motion to set aside. I, Scott Myers, being duly sworn, state as follows. So, this is Kyle's lawyer. Wait. No. Wait. I just read this. Sorry, I'm reading the same thing. I just read that one. We're on 30. There we go. There we go. This makes more sense. State of North Carolina, Guilford County, Steve McCrae, plaintiff versus Kyle Russell Curtis, defendant, in the General Court of Justice, Superior Court Division, 19 CVS 8163. Kyle Curtis's amended motion to set aside entry of default and partial default judgment. How I can only feel bad for Kyle's lawyer having to file this after the last one that just was like, yo, he lives there though. Pursuant to Rule 55D and 60B, the North Carolina Rules of Civil Procedure, defendant Kyle Russell Curtis submits this amended motion to set aside the entry of default and partial default judgment entered against him in this case. The particular basis for Mr. Curtis's motion are detailed in the supporting brief. Whereover, defendant Kyle Russell Curtis respectfully requests that the court set aside the entry of default under North Carolina Rule of Civil Procedure, Rule 55D, set aside the partial judgment under North Carolina Rule of Civil Procedure, Rule 60B, and grant all other relief that it deems necessary the 28th day of July 2020. I am curious, and I'd like to know what you guys think. In what world would this help Kyle? I can understand why this would be a detriment to Steve and like limit or make it drag it out longer so that he doesn't get the channel back, but that still doesn't help Kyle. So I'm curious if like anything about this would Dapper says, yeah, I feel bad for Kyle's former lawyer. She got a whole plate of shit in front of her and she just had to sit there and take a bite. Like, she really did not have this poor woman. Like, I don't pity her, but it's like I still feel kind of bad. Like, that's her job. Like, I don't feel bad for her in that regard. Like, I don't think she's anybody who needs pity. It's just such a situation where it's just like I just feel kind of bad that this had to happen to you. The undersigned certificate foregoing has been served on all counsel for the records in accordance, blah, 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 electronic filing. Sweet. So let's see what the brief was. This is the brief in support. Rodent No Last Name for 5 says, you get the feeling in Kyle's mind he's the greatest defense lawyer in history when he's really a rabid weasel in a burlap sack with bat diarrhea. Listen, we're down to clown till we're dead in the ground. Hell yeah. We down to clown. State of North Carolina, Guilford County, Stephen McCrae, plaintiff versus Kyle Russell Curtis, defendant, in the general support of... Actually, Puck needs a boop. Puck, come here. You want a piece of potato? You need a boop. Come here. First you get boops. Boop. Now you get potato. Potato. Ah, good boy. Okay. In the General Court of Justice, Superior Court Division, 19 CVS 8163, brief in support of Curtis's amended motion to set aside entry of default and partial default judgment. Pursuant of Rule 7.2 of the North Carolina Business Court Rules, defendant Kyle Russell Curtis submits this brief in support of his motion to set aside the entry of default and partial default judgment entered against him in this case. Introduction. This case concerns a dispute about ownership rights to a YouTube channel. The plaintiff, Stephen McCrae, filed a 7-count complaint against Kyle Curtis over the dispute. Mr. McCrae, however, served the summons and complaint by certified mail to an address which Mr. Curtis no longer resided. Based on service to that address, Mr. McCrae obtained a partial default judgment. Because Mr. Curtis has not been properly served with the complaint in this lawsuit, the partial default judgment is void under Rule 60b-4. Relevant background. Stephen McCrae filed this lawsuit against Kyle Curtis on August 23, 2019, ECF number 3. On August 30th, 2019, the summons and complaint were delivered by certified mail to 1532 Providence Church Road, Pleasant Garden, North Carolina 27313. The resident of Kyle Curtis's mother, Susan Curtis. ECF number 7, Kyle Curtis affidavit, paragraph 6, attached as Exhibit 1. Susan Curtis affidavit, paragraph 2 to 3, attached as Exhibit 2. Ms. Curtis signed the certified mail receipt, Susan Curtis Affidavit 2, When the summons and complaint were delivered to Mrs. Curtis's residence in Pleasant Garden on August 30th, 2019, Kyle Curtis was no longer living at that address. See Kyle Curtis Affidavit, paragraph 246, Susan Curtis Affidavit, paragraph 4. Mr. Curtis has resided at 2543 Anna Garrison Road in Charlotte, North Carolina since July 16th, 2019, over a month before Mr. McCrae attempted service at the Pleasant Garden address. 1. Kyle Curtis Affidavit, paragraph 246, Suzanne Curtis Affidavit 4. To date, Mr. Curtis has never been served at his address in Charlotte, North Carolina. Kyle Curtis Affidavit, paragraph 5. Mr. McCrae moved for entry for default on October 2nd, 2019, and the court entered an order for entry of default the next day, ECF number 9. Mr. McCrae then filed a motion for default judgment on October 19th, 2019, and renewed motion on November 14th, 2019 to correct an error, ECF NOS 1914. The court entered a partial judgment on default on January 23rd, 2020, ECF number 17. The court also sent, notice that we're going to default if you don't show up, on July 13th, 2020, McCrae's counsel filed an affidavit stating that mail addressed to Mr. Curtis at 2435 Anna Garrison Road in Charlotte had been returned as non-deliverable, ECF number 29. Mr. Curtis' street address is 2543. So one of the reasons why that one address didn't showed back as vacant and not deliverable is because the address was written in, the address number was wrong. So 2435 versus 2543 Anna Garrison Road. As Mr. Curtis explains in the affidavit accompanying this brief, in a previous filing with the court, Mr. Curtis mistakenly stated that his street address. So the reason that mistake was made was because that's the address Kyle gave. So Kyle gave the wrong address in his previous motions or in his previous affidavits or whatever, in his previous filings. There we go, that's what I'm looking for. So the reason that the address in his previous filings came back vacant was because he gave the wrong number to the court and therefore to Steve's lawyer. Kyle Curtis Affidavit, paragraph 3 and Exhibit A. Well, interestingly enough, this address was the one being used the whole time and he never said whatever. This was merely a typo. To correct the address, 2543 Anna Garrison Road appeared numerous times within the same filing that contained the typo. See ECF number 20 at 11 to 17, Kyle Curtis Affidavit, paragraph 3, and Exhibit B to D. I think we can all probably be like, yeah, that was probably just a typo. After Mr. McCrae obtained the partial judgment, Mr. Curtis filed a motion to set aside the default judgment, followed by a revised motion, ECF NOS 1920. Since that time, Mr. Curtis has retained the undersigned counsel to represent him in this matter. This amended motion as follows. Because he lied about having an attorney. Quote, for good cause shown, the court may set aside an entry of default, and if a judgment by default has been entered, the judge may set it aside in accordance with Rule 60B, end quote, NC General Statute, North Carolina General Statute, paragraph 1A-1, Rule 55B. Rule 60B-4 provides that a defendant may be relieved from a default judgment if the judgment is void, ID paragraph 1. Sorry, I think that I heard the people upstairs. ID paragraph 1A-1 Rule 60B4 Gibby versus Lindsay 1498 NC App 470473-560 SE2D 589591 2002. A defect in service of process is a jurisdictional defect that renders any judgment or order obtained thereby void. Thomas versus Thomas, 43 North Carolina, App 638-645-260 SE2D 163168 1979, citing Sink versus Easter 284 North Carolina 555-561-202 SE2D 1382. So wow, why did I get a 2 from? 143 1974. Service of process is defective if it does not meet the requirements of Rule 4J. See Gibby 149 North Carolina App at 473560 SE SE2D at 591 to 92. At least all the citations are now from North Carolina instead of like what Kyle filed before, which was showing like Washington. The provisions for setting aside default judgment are to be liberally construed so as to give litigants an opportunity to have a case disposed of on its merits. Estate of Teal versus Darby 129, North Carolina App 604, 607, 500, SE2D 759, 762 in 1998. Thus, any doubt should be resolved in favor of setting aside an entry of default. John Henry Spainhour and Sons Grading Co. versus Carolina E.E. Homes Inc. 109, North Carolina App 174, 183, 426, SE2D 728, 733, 1993, quoting Beard versus Pembauer. 68, North Carolina App 52, 56, 313, SE2D 853, 855, 1984. Argument. The partial default judgment is void because Mr. Curtis was not properly served. Proper service is a prerequisite to personal jurisdiction. Because Mr. Curtis has not been properly served with the complaint in this case, the partial default judgment entered against him is void under Rule 60B-4. Rule 4J1C, I'm pretty sure that's a 1, not an L. Pretty sure that's a 1. Rule 4J1C contains the requirements for service of process on individuals by registered or certified mail, the method that Mr. McCrae used here. Rule 4J1C provides that service by certified mail is achieved by mailing a copy of the summons and of the complaint, registered or certified mail, return receipt requested, address to the party to be served, and delivering to the addressee, end quote. NC General Statute, Paragraph 1A-1, Rule 4J1C, emphasis added. Quote, where a statute provides for service of summons by designated methods, the specific requirements must be complied with or there is no valid service, end quote. Broughton versus Dumont, 43, North Carolina Apps 512, 514 to 15, 259, SE2D 361, 363, 1979, cited Guthrie versus Ray, 293, and North Carolina 67, 69, 235, SE2D 146, 148, 1997. God, no wonder, like, half the people that talk about this case never read the damn thing. Like, really? Really? Moreover, quote, a person relying on the service of a notice by mail must show strict compliance with the requirements of the statute. Fulton versus Mickle, 134, North Carolina App 620, 623, 518, I'm losing it. SE2D 518, 521, 1999, quote, in re-appeal of Harris 273, North Carolina 2024, 159, SE2D 539, 534, 1968. Importantly, quote, although defective service of process may sufficiently give the defending party actual notice of the proceedings, such actual notice does not give the court jurisdiction over the party. Fulton, 134, North Carolina App at 624, 518, SE2D at 521, quoting Johnson versus City of Riley, 98, North Carolina App 147, 149, 389, SE2D 849, 851, 1990, Accord, Thomas and Howard Co. versus Trimark Catastrophe Service, 151, North Carolina App 88, 91, 564, SED2D 569, 572, 2002. I think that everybody who is talking about this case ought to thank me for reading all of this, including the people who fucking hate me. No, I'm reading everything, OPT. I am reading everything, damn it. I am reading the citations. You can't stop me. Oh, Puck, what are you getting into? You better not knock over any of my plants or I'm gonna be mad at you. Yeah, I know life's hard. Yeah. Oh, I know. Thank you. I appreciate it. Good job protecting the house. Here, Mr. McCrae attempted to serve Mr. Curtis by certified mail at the residence of Mr. Curtis's mother in Pleasant Garden, North Carolina on August 30th, 2019. This would be such a good argument if it wasn't like the GoFundMe that was recent that had his address, that he used it as the business address, that he used it like... If it wasn't for the fact that it was his address, this wouldn't be a bad argument. Mr. Curtis, however, was living in living in Charlotte, North Carolina on that date and had been since July 16th, 2019. Kyle Curtis affidavit paragraph 2, 6, Suzanne Curtis affidavit paragraph 4. To be sure, a lease attached to Mr. Curtis affidavit shows that beginning in July 15th, 2019, Mr. Curtis entered into agreement to rent the property located at 2543 Anna Garrison Road, Charlotte, North Carolina. See Kyle Curtis's affidavit exhibit B. Moreover, Mr. Curtis' financial statements and even his tax form for 2019 reflect that Mr. Curtis resides in Charlotte, North Carolina, and has since July 2019. See Kyle Curtis affidavit exhibits C and D. I figured it out. In sum, Mr. McCrae's attempted service of summons and complaint to an old address was procedurally defective. That defect is a jurisdictional one that renders the partial default judgment against Mr. Curtis void. According to Mr. Curtis' request that the entry of default and default judgment be set aside. Conclusion. For the reasons stated in this brief, defendant Kyle Russell Curtis respectfully moves the court to set aside the entry of default under North Carolina Rule of Civil Procedure Rule 55D to set aside the partial default judgment under North Carolina Rule of Civil Procedure, Rule 60B, and to grant all other relief that it deems necessary. This, the 28th of July, 2020. Certificate of Compliance with Business Court Rule 7.8. The undersigned is in accordance with Business Rule 7.8, certifies foregoing brief, exclusive to the case caption signature blocks required certificates, contains fewer than 7,500 words as reported by word processing software, and a certificate of service. In brief, support. So shall we look at the support? Or shall we wait for next time? Let's look at the support and then see what the, let's look at the support and then see what, next time we'll see what the, what Steve's lawyer had to say about that. So this will be the affidavits that she was referencing in her brief. And for some reason, we're at the bottom. Why are we at the bottom? Because this is what I just read. That's why. Where's the thing that I was reading? I'm at 31, right? Brief support. Oh, I read the support. Now we're looking at the exhibits. There we go. These are the two things I'm looking for. Jesus. Exhibit 1. State of North Carolina, Guilford County, Steve McCrae, plaintiff versus Kyle Russell Curtis, defendant in the General Court of Justice, Superior Court Division 19, CVS 8163, affidavit of Kyle Russell Curtis. So let's see what Kyle had to say. Affidavit of Kyle Russell Curtis. Kyle Russell Curtis, being duly sworn, states as follows: my name is Kyle Russell Curtis. I am over the age of 18 and am competent to provide this affidavit. I am a citizen and resident of Mecklenburg County, North Carolina. My address is 2543 Anna Garrison Road, Charlotte, North Carolina 28263. I should have, you know what I should have done? I should have set up a counter so that it would ding every single time that there's perjury. I'll let you guys count. If one of you wants to actually listen to this and count every time there's perjury, please let me know the number at the end, even if it's just this one affidavit. I lived at this address since July 2019. I count at least 2 so far. On February 5th, 2020, I executed an affidavit that was filed in this case on February 12th, 2020, attached as Exhibit A. That affidavit contained a typo. It stated that my street address was 2435 Annis Garrison Road rather than 2543 Annis Garrison Road. My correct street address is 2543 Anna Garrison Road. Appears 7 times in the document accompanying that affidavit. I have attached documents to this affidavit showing that I resided at 2543 Anna Garrison Road, Charlotte, North Carolina 28263 at the time that the complaint in this case was filed and mailed to Pleasant Garden, North Carolina address in August 2019. Those documents include my lease for 2543 Anna Garrison Road, Charlotte, North Carolina 28263, which commenced on July 15th, 2019, attached as Exhibit B, a credit card statement for August 1st to 31st, 2019 period, attached as Exhibit C, and my 1099 tax form for 2019, attached as Exhibit D. As of today, I have never been served with the complaint nor any other filing made in this case at my address of residence, 2543 Anna Garrison Road, Charlotte, North Carolina 28263. I have reviewed the affidavit of service of process that Stephen McCrae's attorney filed in this case on October 2nd, 2019. That affidavit shows that the complaint filed against me was mailed to my mother's address. So you reviewed it on October... Oh, wait, no, maybe that's not when he reviewed it. That's just when it was filed. Before I jump the gun here. Perjury hashtag. Yeah, that'd be good. Yeah, Seshi, I like that. That affidavit shows that the complaint filed against me was mailed to my mother's address, 1532 Providence Church Road, Pleasant Garden, North Carolina 27313 in August of 2019. My mother, Susan Curtis, signed the certified mail slip attached to the affidavit of service on August 30th, 2019. I did not reside at 1532 Providence Church Road, Pleasant Garden, North Carolina 27313 on August 30th, 2019. This is the 28th day of July 2020. Signature block on next page. There's the notary. You guys remember that the notary looked weird on one of the things, and that also there was this Susan's signature, and there was also that the what was the other one? There was that he didn't actually say he never received it until after he filed with the court. There's the affidavit. Okay. Exhibit A. In the General Court, State Superior Court, Stephen McCrae, Honorable Judge, affidavit for Kyle Curtis, the affidavit, Kyle Curtis, notary, blah, 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 5th day, February, blah, 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 blah. Exhibit B. Rental agreement, month to month, date July 15th, 2019. Agreement between Benjamin Potts, last name spelt wrong, owners, and Kyle Curtis, tenants, for the dwelling located at 2543 Anna Garrison Road, Charlotte, North Carolina 28263 location. Tenants agree to rent this dwelling on a month-to-month basis for $600 per month, payable in advance on the 20th day, of the calendar month, which owners will give tenants a rebate discount of $100. The first month rent for this dwelling is $600. Security cleaning deposit of this dwelling is $300. If refundable, it is refundable if tenants leave the dwelling reasonably clean and undamaged. Tenants will give 30 days notice in writing before they move and will be responsible for paying rent through the end of this notice period or until another tenant approved by the owners has moved in, whichever comes first. Owners will refund all deposits due within 14 days after tenants have blah, 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 rental agreement, blah, 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 mark if any, accepted, blah, 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 Kyle Curtis. We read this before, so you can go check it out. Notice how he omitted here whether she did or did not hand over the summons. Violation of any part of the agreement or non-payment of rent when due shall be cause for eviction under applicable code sections. The prevailing party shall not recover reasonable legal service fees involved. Tenant hereby acknowledge owner Benjamin Potts. Date Kyle Curtis. Date. Exhibit C. Discover statements. He said it on his live stream. His mom left it on the counter for him and he got it. Todd. Here's the Discover statements for 2543 Anna Garrison Road, Charlotte, North Carolina, 28263, and then blah, 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 blah. And then there's another one with the account. Oh, I didn't, the date, sorry. The date's the important part. Statement period, August 1st to August 31st, 2019. And then this one is same account number, November 1st, 2019, November 3rd, 2019. 25 Kyle R. Curtis, 2543 Anna Garrison Road, Charlotte, North Carolina, 28263. Account number ending, deposit slip. Exhibit D. I can rotate it now because I'm a smarty pants. I rotated the wrong way because I am dumb. There we go. Payers 10, recipients 10, 84 numbers, recipient Kyle, street address 2543 Anna Garrison Road. Yay! And Exhibit 2, Affidavit of Susan. Okay. North Carolina, CVS, Stephen McCray, plaintiff, Affidavit of Susan. Why does this look like this? Oh, God. That's unfortunate for me. State of North Carolina, Guilford County, Stephen McCray, plaintiff versus Kyle Russell Curtis, defendant in the General Court of Justice, Superior Court Division, 19 CVS 8163, Affidavit of Suzanne Curtis. I'm going to zoom this in so you guys can see it a little bit better. Affidavit, not that that's necessarily going to help. Affidavit of Suzanne Curtis. Susan Curtis. Susan Curtis being duly sworn states as follows. 1. My name is Susan Curtis. I am over the age of 18 and I'm competent to provide this affidavit. This affidavit is based on my personal knowledge. I am a citizen and resident of Randolph County, North Carolina. My address is 1532 Providence Church Road, Pleasant Garden, North Carolina, 27313. My son, Kyle Russell Curtis, is named as the defendant in the above captioned lawsuit. On August 30th, 2019, a summons and complaint addressed to Kyle Curtis were delivered by certified mail to my residence at 1532 Providence Church Road, Pleasant Garden, North Carolina, 27313. I signed the certified mail slip. When I signed the certified mail slip on August 30th, 2019, Kyle Curtis was no longer residing at 1532 Providence Church Road, Pleasant Garden, North Carolina, 27313. Since July 16th, 2019, Kyle has resided at 2543 Anna Garrison Road, Charlotte, North Carolina, 28263. As of the date of this affidavit, Kyle still resides at 2543 Anna Garrison Road, Charlotte, North Carolina, 28263. This the 28th day of July, 2020. Susan Curtis. And then public notary. Anybody who's curious about the signatures, since, spoilers, Kyle faked Ben's signature, I think it's worthwhile to look at any other signatures that have been presented to the court at this time. And I think there is a good place to end, because next we get to see Steve's lawyer's response to this, especially after this little... No, not that one. Not that one. This one? After this spicy little boy. I'm glad that there's still things in this case that just make me laugh. They're just funny. So the double M here on English language, and it's just talking about proofreading. The double M killed. All right. Next, after seeing the new motion, let me know what you guys think. You guys tell me if you guys saw any perjury so far. I don't know. You guys let me know, because I'm not sure if perjury counts the number of times you say the same lie over and over again. So, like, if I say, like, my hair color is blue, is that only one count of perjury if I say my hair color is blue on multiple occasions? I'm curious. I'm not sure what that would be, but yeah, this guy's got it right. Time to take out the trash. Thanks everybody for coming. move on to part 6. We will see what Steve's lawyer had to say about those affidavits and other such things. I can't wait for Ben to step into the spotlight. Thanks, everybody. Like, share, sub, hit the bell, become a member if you'd like. Conversations also going on in Discord. If you become a Patreon or a member, you get links to that. You also get the emotes and stuff. So Pucks in the chat, Trigglypuffs in the chat. And I hope everybody has a good week coming up. And I will see you guys, same bat time, same bat place, tomorrow. Bye.